now, hey now, dream is over. Okay, good morning, everybody. It is the 9th of July. We've got 2 customers here so far. More on the way. Looks like Jeanette Jackson will be our public defender today. She's out in the hall talking to people. Another beautiful Michigan summer day. Rode my bike this morning. Still light out. Good to be here. I just had a guy stop in to say hello. Haven't seen him in a long time, which means he hadn't been in trouble in a long time. Tell me he's doing okay. And he had some landlord tenant questions that I had trouble answering because I might have to hear his case. But anyway, I don't think he's been in trouble in quite a while, which is probably good. We do have misdemeanor arraignments today. I have a hearing on a speeding ticket. I'm not sure how that got stuck in here, but I have a formal hearing on a 40 and a 35. I'm not sure what that's about. And good morning from everybody everywhere. What I know about the Canadian prairies, I learned from Neil Young. Well, it is 8:14, so I guess I'll get started. Thank you for saying good morning. And it is a good summer day. A lot of setbacks in life is that summer isn't long enough. It's not in Michigan. So we try to enjoy it while we have it. Eat outside. Mow my lawn. All right, good morning, everybody. Peter James Fair, would you come forward? Good morning, sir. Why don't you stand right at the podium there? Mr. Fair, you got a ticket for driving with no insurance, driving with improper plate, and another improper plate is a civil infraction. Those usually have to do with money or lack of money. No insurance and no plate. We get lots of those combined. Ms. Jackson indicated you wish to plead not guilty and get a pretrial with the prosecutor.
Yes.
Are you going to get insurance?
Yes.
What are you doing now?
Right now I'm trying to make it my full-time stocking at Meijer right now at nights, and it's part-time at McDonald's right now as well.
You've been at Myers, so you got 2 jobs?
I got 2 jobs right now. Yeah. Last week in 8 days, I did 108 hours between the 2 jobs.
Holy moly.
I've been working hard. I've been trying to catch up some bills. I had some tax obligations and stuff to catch up. So I've been trying to work on.
Well, one of the bills I want you to catch up is your unpaid ticket. You got a break where they allowed you to plead to allowing another to violate the motor vehicle code back in 23, and you owe $355.
I can pay that today. I lost the thing, and I didn't ever get around to calling the courthouse to get the
that'll help
information.
your circumstance. Now, as you know, you and I are cousins. Your father was my first cousin. And so that makes you my first cousin once removed, I believe. Do you have any objection to me handling your case?
No.
108 hours in a week. You don't have time to get in trouble. But obviously you're working hard enough to, I would just assume, well, I'll leave it up to you. You can pay that today if you wish to, but when you come back in, you need to bring proof of insurance and plate. Need to pay old ticket, which is 231981 SM, and get insurance and plate. Set pretrial with prosecutor. Are you missing work right now?
Oh yeah, I'm missing McDonald's right now.
All right. Today is July 8th, Let's continue this to August 7th. Was that enough time?
Yeah.
I think your license is valid. You had some issues with that.
Yeah, I got that all straightened out. I even got the truck all legal. I had an issue with, they didn't like my insurance for my health insurance for my car insurance, and I hadn't opened the other letters to see that they had canceled the insurance yet. I've been so busy,
All
so
right, well, let's get this squared away. That will be a Thursday. That'll be August 7th. Well, you're making your way in your world. How's your brother doing?
he's doing all right. He's moved back into Michigan or back into Indiana. He's back in town at least.
I heard that Nancy's not doing very well.
Yeah.
All right, Mr. Fair, here's the fine that you owe. That's just the file number, and here's your notice. We'll pick this up again in about a month, and you'll come in and meet with the prosecutor and bring proof of insurance and plate. Well, I think he's gonna be all right. There are a lot of people working 108 hours a week to try to catch up on their bills. Let's talk to Eric Rainey. This is file number 25838 SM, People versus Eric Richard Rainey. That's you, sir?
Yes, sir.
You got charged with malicious destruction of property, over $200. It's alleged that on April 10th, you went to Jennifer Shoulder's apartment. You wanted to live there, but she didn't want you to live there, so she alleges that you punched her TV and broke it, did several $100s worth of damage. So the prosecutor charged you with that. When was your baby born?
It's not my baby. When?
21st of April.
April 21st.
So this was 2 weeks before your baby. Who's Jennifer Shoulders?
It's my birth mother.
What?
My
Oh, it's
birth
your,
mother.
it's your mother, okay.
She's not my mom, but she, you know what I mean?
All right, she's your biological mother?
Yeah.
Okay. Then you got charged with resisting and obstructing police
Yeah.
officers.
Okay, so I have a question. How do I get a resisting and obstructing if I was never told, hey, you're under arrest, or I was never trying to be under arrest, or I didn't do anything wrong? I don't understand why I got a charge for
we'll find out.
resisting and obstructing. If I didn't, wasn't never told, hey, you come here, you're under arrest, and I took off running, I understand it. Or if they try to put me in cuffs and I spun around and try to take off, I get it. But I didn't do nothing wrong.
All right, well, I'm gonna get you a lawyer and you can
For
pursue
that,
those.
for that RNO stuff, I do need a lawyer. I don't want to see the body cam video because
Well, I'm gonna
I
get you a
didn't
lawyer.
do nothing wrong. I was trying to save some dude's life who wrecked on a motorcycle. And the cop was out of line. Van Dyke was out of line
Okay,
because he got a vendetta against me for some reason. I don't know what his problem is, but he probably should leave that at home. You know what I mean? Gotta bring that shit.
I don't know enough. I don't know anything about it.
Well,
But what I'm gonna do, I do know that you owe
I
me.
mean, he keep coming at me.
Stop.
I'm gonna figure out how to press
I'll
charges on
I'll
him.
get a lawyer for you. You got $516 worth of unpaid fines and
I
costs.
know I'm working on it.
And you got a new baby and you're still doing foolish stuff like this.
I didn't do that, so I mean,
All right, well,
I didn't do that. That whole case is foolish because I didn't do it.
all right. Somebody keeps posting your bond, which is good for you.
Because they know that I shouldn't be in there because it's false allegations anyway. Her
Okay.
TV was broke a week ahead of time. Her TV was broke a week prior before she said I did it. They did that.
All right, well, we'll sort both of
She's
these
just trying to
out.
get a new TV.
Defendant
I was
pleads
12 years
not
old.
guilty to each case. On the felony, I'm gonna set a pre-exam conference.
I want to see body cam videos and all
Okay, we can ask for that.
that. I didn't do nothing
Set
wrong.
PEC
I
pre-exam
said you
conference for 7/22/25 at 8:30. Unfortunately, I won't be here that day, but Mr. Tim George will be. And Judge Pattison will be. Set the preliminary examination for July 29th. I will be here that day. But I won't be doing pre-exams. Or, yeah. And I'm gonna appoint an attorney on the misdemeanor. Set a pretrial.
Can I get Nostinger or?
Well, you're gonna get probably Mr. Timothy George. He's very wise. He'll sort all this out. Solve all your problems. For 7/22/25 at 8:30. Now you need to make an appointment to go see him. His office is in Sturgis. And so you've got 80 entries or more in our system. You keep doing dumb stuff.
I've been here a long time, you know. I've been here
Yeah,
30
and I
minutes.
wouldn't mind if you
Hey,
didn't come back anymore.
I have a question. It's not nothing about
Yes.
none of this, but I had gotten into some trouble in Florida, right? Remember when I moved
Yes.
down to Florida on 17, I got into some trouble. I did a lot of that probation. In 4.5, I signed a 36 month suspended sentence, but I did 4.5 years of probation. Good. I moved back up here. I relapsed and my life went downhill, but I want to move back to Florida, but I can't because I got warrants
Well, in here or in Florida?
in Florida.
Well, I can't help you there.
You can't. I mean, what do you think? Did they give me the whole 36 months?
I don't know the answer to that.
It was
My
15
advice
years
was,
ago.
my advice would be
was
stay out of
15
Florida
years
or
ago.
get a lawyer to help you with it in Florida. But you also had an injury. You got hurt. You had some medical problems, didn't you?
Well, I mean,
Within the last couple of years, you were in the hospital for
in
some
the
stuff.
mental hospital, right? That we
Yeah.
talking about?
Yeah,
Yeah, I mean, yeah, I was in the cold water hospital. I was trying to get my disability, but they denied me. I'm trying to get a lawyer though.
all right. Well, you got a lot on your plate, so we're gonna get a lawyer for you. Your next court date is July 22nd at 8:30.
So I got
Call
one.
your lawyer.
I got one on the 17th too,
No,
because they told me I have one on 17th as well. This last time for the RNO.
I just took care of the RNO.
Okay, all right.
So you don't need to worry about that. So your next date, 7/22. You don't always show up on the right date.
I know, but
So make sure you got it squared away. All right, you're good to go. I'll see you.
Great.
I'll be struggling away on Mackinac Island on July 22nd, but somebody will be here.
Thank you.
He's right. That was a confusing set of facts. I didn't know anything about it. It was given to me late last night. He was gonna be here anyway, so we just did the arraignment now. There was some sort of motorcycle accident and there were a bunch of people there. And Mr. George will sort it all out. Except, no, it's a county case, not a Sturgis case. First matter is People versus Cody Wayne Matheny. Good morning, Mr. Matheny.
Good morning.
You're here, your mom brought you. Daniel Frazon, your probation officer, is here. And he set this for a probation violation arraignment. Let's talk about what the actual allegation is. The probation violation petition alleges that you failed to report on a monthly basis, failed to notify a probation officer of your change of address, failed to pay fine and cost, failed to abstain from the use of drugs and alcohol or test on demand, and failed to seek or maintain work or employment. You were placed on probation quite a while ago, a year and a half ago, February of 25, for original period of 6 months for a malicious destruction of property charge and a strange set of facts where you broke your neighbor's window. Because it was such a strange set of facts, I put you on this probation. Daniel indicates that we were still doing this probation. You got placed on not February of 24, February of 25. So we're in a 6-month probation. We started off bumpy right off the bat. the neighbor called in April and said that you were again acting out and yelling at them and they were concerned. Then you didn't report in April. You were late. Then you went AWOL. Your mom even put out a missing person for you. Daniel tried to get a hold of you. You didn't report in May, June. And then we heard you were living in Greenville, Michigan. And they wanted you to contact your mother. So that's the last we heard. And I'll read what Daniel wrote here. The officer believes, the officer being Daniel Friesine, that the defendant is suffering from drug usage as well as some mental health struggles. He is not reported consistently, is misreported, not tested as instructed, is not holding gainful employment, has not obtained a substance abuse assessment. In general, he's done whatever he wanted to do when he wants to. The officer strongly believes there is continued drug use and he has not updated his living status with the probation department. He's recommending the 5 deferred days of jail and we revoke your probation. When I did the sentence, recommended 30 days jail, 25 days credit, and I left 5 days hanging over your head. I ordered $1,390 worth of fines and costs, which apparently you've paid. No assaultive behavior and no contact with the Zarza family, who were your neighbors. That was in February. Daniel advised as of today, you have paid your fines and costs and oversight. You don't really like being on this probation much. Point of fact, you'd probably just like this to be over with. Is that true?
Correct. Yeah, I don't, yeah,
Are you back
half of
in,
that doesn't even make sense to me, so.
are
I
you
don't
back
know.
in Three Rivers?
I think I'm just targeted, but,
Are you back in Three Rivers or you're in Greenville?
I'm all over the place, I guess. I'm trying to, escape all the bullshit that I have to deal with in my life that I can't seem to get past. I don't know.
Well, you can't escape from yourself. Daniel, I'm glad to hear he's paid the restitution. Your recommendation is essentially give the 5 days in jail and revoke the probation.
Yes, and I agree with what the court's determined too. He's been very not amiable with this officer throughout this whole process, and I think I don't know if he feels like he's been wrong or slighted or what, but I haven't been able to reach him mentally or actually physically. So he's pretty much done what he's wanting. I don't see there any sense on it. He's not gaining everyone. He doesn't want to be on it. So
I agree. Well, if you admit to the violation, that's what I'm gonna do. I'm gonna give you 5 days in jail. You'll get 1 day, probably good time, and then you'll get out and I'm gonna revoke your probation and get off your back. However, you don't have to do that. You have a right to have a hearing regarding the violation. You have a right to have an attorney regarding the probation violation. It would have to be established beyond preponderance that you violated your probation. I feel bad because I didn't accomplish much here. You got some mental health issues we never really got to the bottom of. And you're trying to run from them, but everywhere you go, there you are. So I wasn't very successful in that. But so Mr. Matheny, that's your option. If you wish to plead not guilty, I'll appoint a lawyer and set it for a hearing someday in the future. If you simply wish to admit, you're going to go to jail and get out in 4 or 5 days. What would you like to do here?
I'm just gonna say not guilty, and I don't have any mental health issues. I just think that I'm highly targeted and I don't respect that. I have to take I have to be accountable for everyone's actions when, I don't know. I don't even know this guy, and this guy said that I was yelling at him. He said I broke his window. So I pled guilty to this and I ran from it. And I wasn't gonna show up here because I wasn't guilty of breaking the window and I got accused of it, so I had to take this plea, I had to sit in jail. And I don't know what, I don't
As
know.
I recall, there's a video of it, of you doing this.
I'm not guilty. All I know
Well, you
is
are guilty because you pled guilty. And the time to plead not guilty is long since passed. You pled guilty and you've been convicted, but I thought there was a video of it. At any rate, it's your right to plead not guilty. Thank you for getting him here. I know you're struggling too. Sometimes people with mental health problems have the least insight to the fact that they do have mental health problems, and that's where you are. You believe you don't have any, and I believe you do. Maybe the truth somewhere in the middle, but what you're doing right now isn't working so good. Did you find work anywhere since I saw you last?
I reapplied, but I don't really know if I want to live around here, to be honest with you.
Well, I'm
Too much
okay with
trouble
that
for me.
if you want to go wherever you want to go. But somewhere where you go, you're gonna have to get some way to support yourself. All right, I'll appoint an attorney and set a PV hearing. I don't know when that'll be. I'm gonna send you out to the counter. The original attorney was Paul Gibson. So the allegations are that you failed to report, failed to test, and failed to do much. Although you did pay everything off, so I commend you for that. And the portion of that was restitution for the window. I wish I had a better answer for this, but I don't. I don't need a test.
He took one in a second and I got that back and it was negative.
Very good, very good. I'm very happy to hear that. July 2nd was negative?
That's correct, Your Honor.
All right, very good. All right, I agree, Cody. You feel like you got the weight of the world on your shoulders, including this. One way or another, I'm gonna get off your back. But you're gonna have to find your solutions without me trying to get you there. So I'm gonna have the court officer take you out. We got a PV hearing. I'll give you a date and we'll appoint an attorney and I'll see you. Probably won't be until August. All right, you're free to go. I'm glad you were here.
Yes, sir. Thank you.
Okay. Sometimes, and today's one of those days, I feel like I'm often not accomplishing much by placing people on probation. Except hopeful for outcomes that don't come. This is another one. Might be better off I just gave everybody 30 days in jail and called it good. All right, we did have a trial on a speeding case set for 10 o'clock. Apparently, the Township of White Pigeon worked out some sort of plea agreement with the defendant. He completed a traffic safety course, and the case, I think, is being dismissed. Good morning, sir. Are you John Wadley?
Oh, yes, sir.
This is Judge Middleton. We've met, but I needed to talk to you this morning. Mr. Keith Stickley, the Chief Public Defender, is here. And also, Mr. Josh Robert, the Chief Assistant Prosecuting Attorney, is here as well. You got arrested last night for failing to appear for a probation violation arraignment. Where did you get arrested?
Oh, my mom's.
In Michigan Avenue?
Yes, sir.
They came specifically to get you?
He pulled up. I was working on my wife's car and I pulled out and then I turned around right by him. He was parked on the side of the road. I turned around right there and pulled back in and I showed him the oil where it was leaking and I was trying to fix the car. I was going to appear. I tried to get a hold of Miss Davis about my kids. I just found out I had two kids and one's racist and the other one is mixed. And I got caught in between the two of them.
All right. Well, Mr. Bush was your lawyer on this and your probation officer was Autumn. So let's talk about this. You've been off the radar. You've had a rough couple of years. If we go way back,
Sorry, I didn't even know I had.
2022, resisting and obstructing and domestic assault. 2020, assault with a dangerous weapon, 3 counts, and resisting, obstructing. And then this
Yeah, I was
count
drunk and
started,
rage
hold
baiting.
it. Started as assault with intent to do great bodily harm, domestic violence, second offense, 3 counts. You entered a plea to domestic violence, second. 2 counts, and I put you on probation. I gave you 62 days and deferred 60 back to last May. And then you went off the grid. So I did a bench warrant for you last October. I haven't seen you since. Let me talk about the actual petition. I'd like to ask you a bunch of questions, but your lawyer isn't here. You were struggling with methamphetamine, you were connected to CMH, and then we just lost track of you. The allegation is that you failed to abstain from the use of drugs and alcohol and then failed to appear for your probation violation in October. I have 60 days of jail hanging over your head, which is likely to be imposed with your issues. I don't know where you've been. You've been just hanging around waiting to get arrested, I guess. But at least the good news is you won't have to look over your shoulder for a warrant anymore. I'm going to show a plea of not guilty. I'm going to appoint an attorney. Set a PV hearing. You have a history of assaultive behavior and you didn't show up and you just been under the radar.
And that rage baiting, they set me up for that domestic. That was wrong. I got a detective on this that's working on this from the FBI. I'm serious. I'm not playing with this no more. I didn't even know I had kids. These guys are really wrong doing this to me.
Well, you did this to yourself. You just quit showing up. You quit going to your treatment. You quit reporting to your probation officer, and you just got arrested. So, like I said, we're going to resolve this. But I'm sorry. Go ahead.
I'm still doing my treatment. I didn't know I had kids, Your Honor. I know that's no excuse. I should have still came in. I had no clue.
Didn't know you had kids.
Yeah, I got kids. I had no clue I had. They got into a fight. I tried to break it up. I got one kid that's racist and I got one kid that's mixed. I didn't even know I had.
All right, well, that's no reason to not show up for 8 months. So we'll get it back on track. Your bond's canceled. You're going to sit there until we resolve this. Mr. Bush or another attorney will be represented to you. I'll let Autumn know you got picked up. It sounds like you're having either some mental health issues or a meth crash or both. So
No, I got my toes rotten. My toes rotting. I need to get my toe looked at. I gotta get to a hospital. It's the woman said it looked like gangrene. You can see the bone. It's bad.
All right, we'll have the jail nurse take a look at that. We'll get at this sooner rather than later because I'm going to be leaving on vacation and I don't want to make you wait for several weeks. So it'll probably be sometime next week. All right, sir. Well, Keith, thank you. That's something we won't have to do this afternoon. He doesn't look like he's doing real well.
Could you give us the name of the FBI agent you're speaking to? Might be him.
I think his name was Reggie King.
Real quick.
I think, Reggie's still with the FBI, I believe. He's been consulting with him.
Yeah.
Good morning, Mr. Water. Good afternoon, Mr. Water. I'm sorry about the delay. I'll explain here in a minute what happened.
Good afternoon, Your Honor.
Good afternoon. Good afternoon, everybody else who was just saying hello. We're gonna get right to business here. We've been delayed a bit. All right, this is Jonathan Franklin Wadley. Mr. Wadley, your parents are here and they've been waiting patiently. This was set for a probation violation hearing today. The file number is 24120FY. You were charged originally with assault with intent to commit great bodily harm by strangulation. The matter was reduced down to a domestic violence first offense and you were placed on probation. Your probation officer was Autumn Kiefer and she is here today. And she has filed a petition alleging that you violated your probation. I read this to you when I saw you last week, but let me repeat it. You were placed on probation in May of 2024 for 24 months for domestic violence. The allegation is that you failed to abstain from the use of alcohol or drugs or submit to a test upon demand. A probation violation arraignment was set for October 9th, 2024 at 9:30, and you never showed up. So there's been a bench warrant out for your arrest since October of 2024. So additional allegation is that you failed to report or otherwise comply with the terms of your probation. So I arraigned you on July 1st, which was last Tuesday. And I wanted to do this as soon as I could. I set it for today, Wednesday, July 9th, because your lawyer, Mr. John Bush, was scheduled to be here on another case, Travis Andrews. I thought, well, good. His lawyer will be here. We'll do it at that time. In the meantime, so we sent a notice to Mr. Bush that day, July 1st. And I've confirmed that it went there. But John's secretary didn't seem to have this on the calendar for today. In the other case, Travis Andrews, Mr. Bush requested an adjournment because he was going to be out of town on business meeting with the client. So the prosecutor agreed, and that case has been adjourned until August. That defendant is in a treatment facility. He's not in jail, and that case can wait a month while we see how he's doing. In your case, you're in jail. You've been AWOL since last September. You just happened to get picked up last week. They came to your house, and as of now, you have $9 days of jail credit.
They consider it 10, Your Honor.
What?
They're considering it 10. I looked
All right.
before I came up.
10 days of credit. Your probation officer, let's go back to the original judgment. Now, joining us, because Mr. Bush couldn't be here on very short notice, is Mr. Keith Stickley. He's the chief public defender. And I appreciate his help here. This started as a strangulation. Your wife alleged that you strangled her. The prosecutor dismissed that charge and the charge of second offense domestic violence for a plea to first offense. In my sentence, I let you out of jail. There had also been a mental health petition, and you went into treatment a little bit at Pines. I gave you 62 days, credit 2 days, and I deferred 60 of the days and let you out of jail, hanging 60 days over your head. So you have done a very poor job on this probation, and your probation officer, Ms. Kiefer, recommends I simply revoke your probation and give you the 60 days jail that I had deferred minus 10 days of jail that you have done. So you would get 50 more days minus good time, which would be something like about 42 days or something. I'm not exactly clear. So I had hoped that you would have an opportunity to talk to Mr. Bush. When I saw you on the first, I thought you were just going to acknowledge that you haven't reported for 10 months and call it good, but I wanted to have an opportunity for you to talk to a lawyer. So here's our options. If you admit that you failed to report and fell off the map, I'm going to revoke your probation and give you 62 days, credit 52 days. And I'll be off your back when you get out of jail. If you wish to have a hearing, Ms. Kiefer can testify that she hasn't heard from you since last September till you got arrested. Mr. Stickley could represent you at that hearing. Mr. Wadley, I also can put you in a room where you can talk privately with Mr. Stickley if you'd like to do that. Frankly, the other thing I wanted to do, you were still pretty twitchy. I wanted to give you some clean time. And so you've been in jail now for 10 days, and I think you're probably clear-headed and thinking clearly. So what would you like to do here this afternoon?
I could talk with the attorney.
All right, could you take him out to the, could you guys open the Zoom room? I know it's a security issue to take him out in the hall, but I think we'll be all right. Mr. Stickley was unable to actually be here. All right, we're gonna take you into the Zoom room and you can talk privately with Mr. Stickley, and that's probably the wisest choice. Mr. Wadley, your parents are loyal supporters. They were here this morning for your pretrial, and they're here again now. All right, go ahead and take him back there. Mr. and Mrs. Wadley, what I'm going to do is let him speak privately with the attorney. We're going to use the conference room to do it. In our new situation, we'll have Zoom capabilities from the lockup.
Right over there in that chair.
Yeah, this was set for 1. It's now 2:15. We had to line up counsel, which I appreciate is coming on short notice, and we had to wait for the magistrate to do the regularly scheduled arraignments. Of course, then there was a holdup from the jail, and there's always a hard time getting everybody in the right place at the right time.
Keith, were you done talking to him privately, or do you need to?
I am, yeah. I don't know what else I can offer at this point.
All right, why don't you bring him back in the courtroom?
Yes, sir. All right, Mr. Wadley.
So, Mr. Wadley, we're kind of back where we were. The allegation originally was that you failed to test, but probably the more straightforward allegation is you failed to report to your probation officer for the last 10 months or so till you got arrested. I told you what I was going to do if you entered a plea to the charge, and what we could do if you didn't wish to do that. So what's your preference here?
I don't understand here. I'm not getting.
Your
my
Honor, if I
counsel.
could,
All right,
Your
so,
Honor, if I could interject, Your Honor. Your Honor,
Yes.
I tried to very clearly and concisely explain what his options were. And I don't know what detail of appropriateness it would be to go in, but I'm not sure he's understanding what I'm saying, or he's
All
not
right,
willing
well-
to communicate rationally as far as
All right, well-
the procedure and what's happening.
well, let's see where we are here.
Okay.
Mr. Wadley, Mr. Bush, I don't know what happened to the notice. You don't have much of a defense. You,
I actually got a bigger defense than.
all right, well, you quit showing up. We haven't seen you in 10 months.
I know, I'm aware of that. I
And-
meant no disrespect. I'm working with, like I said, a federal detective over this. I was rage baited and drugged. Like they had me, I had an ex call the hospital and had me locked in a psychiatric
Well,
ward.
And I knew
And
you
so-
were in a psychiatric hospital for
Okay,
a
now,
while.
my mother-in-law passed away. Now, my ex called the hospital and said that my mother-in-law feared for her safety. Now, my mother-in-law was deceased. I didn't even get to be with my wife while she went through that because of an ex locking me in the psychiatric hospital.
Now, you were in the psychiatric hospital from when to when?
I can't remember the dates.
Yeah, it was last fall.
And I'm not sure what the dates were, but I know that this has all been a series of stages to just like screw me out of my life over an ex. I mean, they've dumped revenge porn. They've had a whole community come after me and blackmail me. I've submitted several reports to the state police that have done nothing to do an investigation. I was beaten, raped. They never gave me a rape kit.
And where was all
Like-
this?
This all happened between Branch County from the time I got arrested and the time that I got released. And this has been going on.
All right,
And
so
I can't get
as
any
of
kind of,
last
And-
June, but when you got arrested here, June 30th,
and I've got several
all right,
letters that.
you
when I
said
was
they
in-
came to your mother's house,
You know,
and arrested you on this warrant.
Yeah.
Okay,
like it's not anybody's real fault, but I've been trying to work with the police and they won't even file any kind of claims.
Now,
They
I
won't do
don't-
investigations.
there's been an open warrant for your arrest since last October.
So,
Any police officer that would have communicated with
That's
you
right.
between then and now probably should have taken you into custody.
okay, now I have several emails where I've sent to the state police with my address, with me. I've called
All
and
right.
made reports and they've done nothing to investigate this. Like,
Well, okay, I don't know about that. If you wish to have a hearing, I guess we can set it when Mr. Bush gets back, but I'm not gonna let you out. You went off the grid for months.
even though
And it's a
tether-
serious assaultive offense that was reduced to a 193-day misdemeanor.
Okay,
I gave you 2 days and let you out, and you repaid me by poking me in the eye with a sharp stick.
so I'll plead
I'm
guilty.
offering to just give you the time served, a time originally ordered, rather than any additional sanction. The only allegation that you would have to admit to was that you failed to report from last October until.
I'll plead guilty.
All right, well, let me ask this. Did I threaten you into doing this?
No, just no officer will do their job. So
All right,
yes.
now, I can't speak to that. Your mother said when you were in the break room, said he doesn't do probation very
I
well.
completed 2 years felony probation, no violations. I completed 2 years parole, no violations. I
All right.
can't do nothing about my kids and everybody drugging me and locking
Well-
me away, dude.
And you told me that
Excuse me,
you,
sir.
you're all right, there's Kleenexes there, that you recently found out you had kids. And you
Yeah.
didn't know that you didn't have any
My
children.
biological kids, I didn't know.
And
have
that
stepkids.
certainly would be upsetting. But none of that stuff, it certainly is concerning, is a defense to the fact that you just quit showing up for probation.
I feel like it was all stacked against me. I feel like this courtroom is like I'm being sold.
Well, I'm willing to give you a hearing, but as I said, it isn't gonna be very hard to establish the facts. Now, I didn't know how much was methamphetamine and how much was mental illness, and where one line starts and the other one stops.
I need witness protection after this.
Um,
That's what's gonna happen.
all right,
But I'll plead
Uh,
guilty. I'll take the 60 days.
All
Get
right,
this over
Keith,
with.
I'm reluctant to go down the competency evaluation path. All right, Mr. Wadley, let me make sure we're on the same wavelength. Did you understand what I'm going to do if you acknowledge you failed to report to your probation officer?
I do, Your Honor.
I'm gonna revoke your probation. I'm gonna suspend all the fines and costs you owe. When you get out of jail, I'm gonna be off your back. Do you understand?
Yes, sir.
Do you understand? You have a right to have a hearing on this if you wish, where we could take testimony, which case I could give you up to 93 days in jail. And do you acknowledge that you failed to report to your probation officer
Shouldn't even be.
from October till you got arrested on June 30th? Do you admit that?
Yes, Your Honor.
All right. John, when's the last time you were connected with Pivotal or anybody from Community Mental
I
Health?
quit doing that since they were trying to take a power of attorney and take off with my life.
I'm gonna ask Pivotal to come see you at the jail. You need some mental health help
It's not
here.
mental health, it's people causing the mental health.
All right, well, stress can cause it.
Well, the feds will straighten us out when I get done with this.
All right, very good. I'm gonna order 62 days credit, 52 days, leaving 50 days to serve.
No, Your Honor, that's not right. 60
credit.
days credit. 10,
Credit 12.
okay, not 52.
Yeah, that's backwards. Leaving 50 days to serve. He had 2 up front and the 10 that he just did. I had it exactly backwards. 62 days credit 12, leaving 50 days to serve. And your probation is revoked. The remainder of your fine and costs are just waived. And you don't have to talk to him, but I'm gonna ask CMH liaison or pivotal liaison to check in with you. They do have a couple of trustee slots inside. Sentenced defendants are eligible for trustee. They make you a kitchen trustee or something, you could get out even sooner. They don't have any outdoor trustees anymore, like the garage or the lawn or any of that stuff. All right, Mr. Wadley, as I said, I'm off your back. I don't wish you any ill.
And I'm sorry that you guys got drugged through this. I got politically assaulted and I know it's not your guys' fault.
All right, you're good to go and good luck.
I'll help you too.
Sorry, I couldn't be of more assistance, Your Honor.
Well, thank you, Keith. I don't know there was a good answer to that. I think there's some.
If he wants to talk to you,
Okay.
yeah.
Yes?
Am I free to go, Your Honor?
Yes.
Thank you.
This, in his mind, he thinks he has 3 wives, 9 kids. Actually.
Yes.
He actually believes this.
Yes, he's got some.
He's really got some mental problems.
He
that gotta
does.
be addressed.
It's not.
I think he understands what just happened, but he's got some delusional thinking, and I'm gonna ask Community Mental Health to go talk to him.
He really believes, in his own mind, he believes this is true, because I think a long time ago, he got so many drugs. I caught him one time trying to electrocute his brain, hanging in the water.
Who do I have in custody? Who's in jail? Okay, should be Patrick Stewart. Okay. He's not there yet, but that's okay.
I'm right here.
Oh, there you are. There, Mr. Stewart. So we'll go ahead and call your cases first.
All right, thank you.
As soon as we get a clerk.
Mr. Clume.
Excuse me?
I said good morning to my, Mr. Clume, Chief Glenn, and to you, good morning, that's all.
That morning.
Okay, all right. We will go on.
You're
No.
okay. I'll catch up.
We'll go on the record in the matter, 02 PA 17 PJ and paternity of CLS, 07 PA 16 PJ in the paternity of EAS, and 10 PA 1 PJ in the paternity of DJP. Appearances are, we have Corporation Counsel Child Support appearing in person appearing in person. We have Mr. Stewart appearing by video conferencing in custody in Burnett County Jail. We have his, I believe, Mr. Keen, are you representing him?
Your Honor, sorry to put him in graphics. I'm just making a special appearance for today on his behalf. And I believe that his father, Patrick Stewart Sr., is present in the courtroom. Or at least he told me he was
Yes.
probably going to be.
Yep, he's observing.
Your Honor,
All right.
would I ask that he be able to come up to a table because he said he was bringing some paperwork. So he may be someone who
He
needs
did
to
not.
speak.
He did?
Child support said they had it.
Child support has it.
Okay.
All right, thank you. So we're here today in these matters for a sanction hearing. Ms. Thomas Schmidt, can you please update the court and give me a little bit of information of where we are right now?
Certainly. I'm going to be rather lengthy, both for the court's benefit and for Mr. Keen's benefit.
I'm just going to ask you to not talk so fast.
Okay, I'll try. I'm dating back to 2019. We've been trying to deal with this issue. And since 2019, Mr. Stewart Jr. has failed to appear for 9 court hearings. He's made 2 appearances prior to today. Both times he's been in custody. He has been given cash bonds, which have been posted twice. And he's been in custody with an unposted bond once that he was ultimately released from. His payment record from January 2024 to present, he paid approximately $25 to $40 a month, approximately every other month, and this was through an income withholding at his father's company between January of 2024 and November of 2024. We've received no payment since December of 2024, except for a bond that was paid by Mr. Stewart Sr. or by Mr. Stewart's mother. I'm not sure which parent paid it, but it was paid by a parent in March of 2025. So I think we are very clearly to a sanctionable point. Mr. Stewart has 3 cases in Burnett County, and over the past year and a half, we've received very little funds, a total of $364 of current support and $371.57 of arrearages, and a significant portion of that was the bond that was posted. And I would also note that the bond motion filed cites a need for Mr. Stewart to be at home to provide care for his dying father, and yet counsel asserted that Mr. Stewart has arranged full-time employment with Troy Maine at his company, which is frankly well known for not complying with income withholding. So that doesn't give me a lot of confidence that child support will be paid going forward through income withholding.
I'm sorry to interrupt. I love your facial expressions, Mr. Stewart. Great. So with that history, we are here for sanctions. There's not a jail sanction to lift a stay on as of yet. So we are requesting jail to be imposed and stayed. All of these matters are quite dated.
2010, 2007, 2002. With most of the cases have very large arrears. And given that history dating back to 2019, and the payment record as minimal as it is, I'm asking for 60 days to be imposed and stayed in the 2002 PA 17 PJ case. I'm asking for 60 days to be imposed and stayed in the 2007 PA 16 PJ case. I'm asking for 75 days to be imposed and stayed in the 10 PA 01 PJ case, with that case being given credit for the 15 days that Mr. Stewart has been incarcerated. Though I would note he's been incarcerated both on the child support warrant and on the criminal case warrant. I'm asking for each of those jail sentences to be consecutive to each other and to any other sentence. And I'm asking them to be stayed with a purge to extend for 1 year, starting the first of the month following Mr. Stewart's most recent release from incarceration. So when he's released from this current period of incarceration, be it on his bond payment, be it upon sentencing, be it upon completion of sentence, whenever he gets out of jail next, the first of the month, the next first of the month, for a period of 1 year, with conditions to make his payments in full and on time. If he's unable to make his payments, to complete job search efforts at a rate of 2 job searches per week to be provided to the child support agency on a bi-weekly basis, to apply for workforce resource center workforce development, and to keep the child support agency informed of changes in address and changes in employment.
All right. So is that all, Ms. Thomas-Schmidt?
Yes, Your Honor.
Mr. Keen, you're making a special appearance on Mr. Stewart's behalf. I'm not sure if that means that you're here to represent him in the matters with what Corporation Counsel has now stated she is seeking, or if you were just simply here to provide some information to the court.
Well, Your Honor, I did send the info. I would represent him on this matter, and since I have just communicated with the phone and my focus was the bond when I talked to him, I'll leave it to Mr. Stewart to decide whether or not the imposed and stayed recommendation by Corporation Counsel is something he wishes to argue or not. However, I would, frankly, the only big difference I would ask is that the 15 days that Corporation Counsels mentioned, instead of being applied to the sanctions, that it be counted towards his upcoming OWI sentencing. My main reason for being here was because Mr. Stewart has a fairly high bond because of the non-compliance mentioned. Mr. Stewart's father has provided a lot of has provided most of the payments, and that Corporation Counsel has mentioned. So my biggest difference in terms of that, I would argue, in terms of purging the condition, would be just that to count the 15 days towards his OWI rather than the child support case because of his father's health. And then
I have a question. What's the case number for the OWI?
Let's see. Oh, sorry, I'll pull that up because that's what you got, Russ. And let me pull up, Your Honor. Sorry, this is wrong.
It should
It's,
be
23
CT 58 and 20.
Yep.
And there's a 23 CF 169 companion as well.
All right, thank you.
Yes.
And I have
Oh,
no
go ahead.
objection to the 15 days being applied to the OWI instead, but because this is first in being heard, I wanted to make sure that 15 days was given credit somewhere. So if you would want to apply it to the OWI, my request on the 10 PA would be 60 days instead of 75.
All right, and so Mr. Stewart, I'm gonna give you a brief opportunity to have a breakout session with Mr. Keen. And Mr. Keen, with the 23 case, are you a public defender?
Yes, and that one I'm a public defender appointment. It's just that I don't believe he's applied for my services in this case. And frankly, considering the proposal of corporation counsel, I don't know that it'll make sense for him to seek to have me handle that overall. I'm here today mainly because he had two different bail issues, so, and the court was wanting to deal with this one first before a potential of his, because he's on a $2,000 cash bail in his criminal case as well.
All right, so I've now opened a breakout session for you to have a brief opportunity to discuss this. If he agrees to the requests and recommendations of corporation counsel. All right. We are back on the record, same appearances as previously noted. Mr. Keen, can you please update the court?
Yes, Your Honor. After discussing his options and obviously poor history in terms of compliance, I've discussed with him that that's probably that this is the corporation counsel's offers is reasonable under the circumstances, and he understands it's imposed and stayed, which means that for a year, you'd have the year to try and purge that condition. So that means that if the corporation counsel and child support believes he's not meeting those conditions, that he'd be entitled to a hearing to show that his failure to pay is not intentional, but that you'd end up with 180 days. In other words, I don't know if Burnett County allows Huber if someone is on a sanction for failure to pay child support. So that's the only thing I would ask about the imposed and stayed, but I've advised him that that objecting to that proposal doesn't really make a lot of sense, and it does help him out by getting rid of the significant cash bond that has been imposed on him for his warrant.
For the record, Mr. Stewart gave a thumbs up that he does agree with this. Ms. Thomas Schmidt, because Mr. Stewart has had his discussions with Attorney Keen, he does agree to those recommendations. So the court will order 60 days imposed and stayed for each of those three cases with the purge conditions that you did state on the record.
Thank you. We will prepare the appropriate orders.
All right, thank you. Then we are adjourned as to Mr. Stewart's. Mr. Erickson.
Take care.
Thank you, everybody.
And for the record, the warrants are quashed.
Yeah, warrants are quashed. I may not be able to answer.
Is he getting out or?
He's still on a cash bond for his other matters, so he needs $2,000 cash to bail out.
And that's for the criminal matter.
That's the criminal matter.
That's all. I think there's no other 2,000 plus 600 plus 300 plus.
No, the child support warrants have been quashed, so he doesn't have to pay or he has to pay his child support, but he doesn't have to pay the warrant to get out of jail for child support. He just has to pay the warrants in the criminal case.
Where is that? How do you?
You go to the clerk. You can go talk to the clerk about that.
Okay.
All right. We will go on the record in the matter 02 FA 71. Oh, Rachel Erickson versus Kenneth Erickson. Appearances are Mr. Erickson appears in person without counsel. We have Stephanie Thomas Schmidt, Corporation Counsel, appearing in person. We're set today in this matter for a hearing. Mr. Erickson, I believe, motioned the court to be heard on a few issues. Briefly, Mr. Erickson, do you want to update the court? Tell me what you're looking at.
Yeah, I wrote you a letter.
I read it.
Okay. Yeah, well, you sent it to me back in, what was it, May 5th for, it was 10 days. And well, when I got out, well, I was doing a job search for twice a week, whatever. Well, then they mailed me this. child support did. Well, then they put out a warrant for me, so I sat another 20 days, and they didn't find me in contempt. So
What are you asking?
what I'm asking is that I said an extra 20 days for nothing. Why would they put a warrant out for my arrest for doing what you told me to do? And they didn't find me in contempt of it. They just made me sit in jail for another 20 days. I mean, what for?
Okay. Ms. Thomas Schmidt?
Your Honor, Mr. Erickson was found in contempt on March 5th. His sentence was amended to 30 days with 10 imposed and stayed, including 1 day of credit for time served. A warrant and commitment order was done on May 14th. Due to non-compliance at that time, we had not received any work searches. We had not received any, I don't believe we'd received payments, but I'll have to double check where that was in the file. No payments, I'm being informed. So we did request the warrant to lift the stay for, I believe we requested the warrant to lift the stay for that 10 days, 10 of those days, and he did sit in jail for 20 days, I apologize. But he did, upon his release from custody, begin supplying job search forms to us. At least one set of job applications. And so that's the history.
Is he in compliance right now?
We have a recent job search dated June 26th. He's due to supply another, but we're not seeking to incarcerate him anymore at this time. We're seeking to let him try to purge himself.
All right, so back on the purge conditions?
Yes.
Okay.
See, Your Honor, my youngest kid is 25. I mean, I know these guys are for child support, but they're for the ones that stay at home that are underage. I mean, they need school clothes, they need stuff for school. Well, when my kids grew 18 and out of the house and moved on, my case from these guys go up to the main headquarters. I mean, I shouldn't have to deal with these guys anymore. I mean, my youngest one's 25. I mean, they don't live around here and they don't go to school anymore.
But Mr. Erickson, so you can understand, these are arrearages. This is the amount of money in child support you should have paid to support your children when they were under the age.
Yeah, but I know that, but she never really had them because she moved up to Tennessee, left the two boys here and took the girls there. I had to serve her papers to bring my daughter back here, and somehow that got thrown out of court. I mean,
Mr. Erickson, I'm hearing your frustration. And I do understand that your youngest child is now 25. However, these are arrearages. The only way that this will be taken care of and would be if you pay all of the child support. I think it's $30-some thousand in arrearages, or if Ms. Hess.
I don't know what her last name is. She'd been married so many times.
If Ms. Hess were to waive all of the rest of the child support that you would have owed her. That's the only way. Because if you had an issue and you said, well, she's not really supporting the kids, the two kids live here and in Tennessee, that should have been brought up in 2012 or whenever that occurred. We can't go back in time and we can't now argue that.
But now if I was found in contempt, I would have another court date, but they didn't find me in contempt. I mean, because they let me out on June 15th. Here's the warrant. That was on Father's Day on a Sunday. I mean, so they didn't find me in contempt. Because I would have had another court date if I would have been found in contempt.
You were found in contempt. You were found in contempt a long time previously, and the court did order sanctions. And in order to not have those sanctions of sitting in jail, you needed to comply with all of those purge requirements, those conditions that the court set, such as giving, I think it's 2 job applications a week to child support. and paying your arrearage.
I did. I've done all that.
We have one,
I mailed it to him. It was government, government center for that county, 7410 County Road K, Saturn, Wisconsin.
Ms. Thomas Schmidt, how many job applications do you have?
we have one sheet with two applications, one for the cheese store Burnett Dairy and one for Hardware Hank.
That's because I brought it up to him. Because I knew there was somewhere in the road, they were gonna say something like that. So I had my dad bring me up to him, and I applied at my dad's work. He's back there. I applied at my dad's work and I applied at CLO, so.
Well, I'm glad to hear that. Make sure you give proof to the child support. With regards to the jail that you sat, you do get credit for that. And I can't, that is what was ordered in the remedial contempt order. And then you ended up sitting that time. So again, the only way that your child support obligation will go away is if you pay all of the amount that you owe their arrearages, or if Miss Hess waives the rest. Okay?
Well, since she got remarried, can't I collect alimony off her? I mean,
No,
since why not?
that's not the law.
Yeah, it is.
It sure is not.
When we got divorced, the other one got married, the other one could surely collect alimony.
That is not accurate at all.
I'm pretty sure it is.
I'm pretty positive it's not. Pretty positive it's not.
Hmm.
And it's not alimony, it's called maintenance.
That's what it's called?
Yes. And there is nothing in the law that says once your ex-spouse remarries, you get to now go after her for maintenance. It's just not the law.
I don't know. I think it is.
You find me case law and you find me the statute that says that, I'd be happy to hear you on that issue.
Right. But I mean, there's only so many jobs I could fly at. I mean, especially when I don't have a car. All I have is a bike, I can only go so far.
There's a lot of jobs that you can do online if you have.
I don't have a phone. I don't have a computer. I don't have any of that.
Well, hopefully your dad can employ you.
Yeah, well, I mean, I'm doing the best I can. I mean, you can only do so much on a bike. I mean,
So what is it gonna take for you to get your driver's license?
I got my driver's license. I just don't have a car. My car burnt up.
Oh, I remember that. I remember that now. Well, hopefully you can work for your dad.
And then with my record, I don't, it's hard to get a job with my record. I mean,
I just keep hearing excuses.
excuse me, well, look at it. I mean, you get a felony, a lot of people don't hire you with a felony.
I understand that, but Mr. Erickson, just because you had a felony doesn't mean that you can stop paying
I didn't say that.
obligation.
I didn't say that. I'm just saying it's harder for me to get one. But I haven't gave up. I'm still trying. I mean, as you
Applied
can
at
see.
A&W?
Where's
We're always
that?
hiring.
Where's that? Siren? Well, I gotta ride all the way from Grantsburg. I mean, that's quite a ways, ain't it? Every day. I mean, that is a ways.
You gotta do what you gotta do. And if it means you have to become a triathlon person or you
Yeah,
want
well,
to
you
get
know,
in shape and ride your bike,
you know how hot it is out there? I mean, the heat would kill you. I mean, more excuses, right? Yeah.
yes, more excuses.
Yeah, well, I like to see somebody else try that every day, riding a bike in the hot heat. I mean,
Mr. Erickson, I'm just gonna be blunt with you. You put yourself in this situation.
no, I didn't.
You did.
No, I didn't.
You didn't?
No, I
You
didn't.
didn't commit the crimes that got you the felonies that
No, I
prohibit
didn't.
you or actually limit your ability to get a job?
No, I didn't.
You didn't get those charges and convictions?
No, I got those charges, but it wasn't from me. I mean, they're all lies that are on there.
All lies. They're all lies. Anyway, okay.
Mhm.
The court is going to credit you the amount of time that you did sit. The purge conditions are back into effect. So all you can do is comply with the purge conditions. Anything you want to add, Ms. Thomas Schmidt?
Just that given the credit, there would be 9 days stayed still.
9 days stayed. All right, so you face 9 days if you don't pay You don't do what you need to do with the purge conditions. But if those are all set, then you start over.
Well,
All right, well, I'm sorry this couldn't have been a little bit more fruitful. Just continue to apply for jobs and give those to Ms.
you
Thomas.
can only apply at so many.
That's what I hear.
Oh, well, how many you think there are out there? I mean, how many jobs do you think I could apply at? I mean, I applied at, I don't know how many, about 8 of them already. I mean, there's only so many in the area. I mean, there ain't like 1,000.
I guess you should just give up then, huh?
Well, I haven't gave up. Well, I'm just saying, how many more, I mean, how far can I can't ride a bike 60 miles. I mean,
You have other
how about,
options.
can I work for, how if I work for this place, you know?
You can borrow money from your father and get a.
They don't
car.
have any money. I mean,
I don't know what else to tell you, Mr. Erickson. I do have to move on with my other cases though on my calendar. So,
but I am doing the best I can. I mean, I'm trying.
I appreciate
mean-
that. So keep doing that, keep giving it to Ms. Thomas Schmidt, and then hopefully you're gonna meet your purge conditions and they'll all be good to go. Okay,
Well, I'll try. I mean, I don't know.
yes, that's all I can say.
I don't want you talking to her.
All excuses. Okay, you're
Excuses.
adjourned. Thank you. Mr. Reynolds. Go on the record in the matter 05 FA 78. In the support or maintenance of NSR. Appearances are, we have Brent Reynolds appearing in person without counsel. Stephanie Thomas Schmidt from the Corporation Counsel appears in person. We're set today for your hearing, your order to show, or is this in order to?
We filed a motion to lift the stay, Judge.
Yes, motion to lift the stay. So, Ms. Reynolds, I appreciate you coming here today. Anything that you would like to tell me up front right now before I ask Ms. Thomas Schmidt for her argument?
I don't have no excuse for it. It's just, I'm trying to do better and stuff. Like for my life, like 10 years ago, I'm doing way better.
Do you understand you have the right to an attorney for this purpose?
No, I didn't.
Well, you would have a right to an attorney. And you can apply for a public defender and or retain your own private attorney for a hearing like this.
Yeah.
Mr. Reynolds, I know that you were in the process of getting your driver's license, but that depended upon what's happening in child support. But
Yeah.
apparently I'm hearing nothing's happening in child support. So then in your other matters, it's going to be slower. So Ms. Thomas Schmidt, can you please provide your recommendation and/or argument to the court?
Yes, Your Honor. Dating back to February 12th of 2025, Mr. Reynolds was found in contempt and sentenced to 35 days in the jail. He was to pay $800 by February 14th. And if not paid, he was to sit 5 days immediately. He did not pay that full amount, but he was in contact with us, provided verification as to why he couldn't pay the full amount out of his, I believe it's tips, but I'm not positive if that's the right term, and provided us what he did get in tips during that time period. So we did not seek to have him sit that 5 days at that point in time. His support order, his purge was to pay his support order of $128.06 per week, plus $23.08 per week on arrearages, with an additional $400 per month to be paid by Mr. Reynolds towards his arrears. Mr. Reynolds did not make those full payments. We've received partial payments in each month from starting in February. We've received partial payments, so not even the full $128.06 per week. Mr. Reynolds did not appear at the last court date and was given a $1,500 warrant, which he paid. But even with that $1,500 paid towards the warrant, He's approximately $3,500 short on his purge. Or since that February 2025 purge date. Given Mr. Reynolds also had discussion about entering an alternative payment plan agreement for the reinstatement of his license, which called for him to pay $2,000 on June 10th and then make his monthly payments commencing July 1st in full and on time. But unfortunately, Mr. Reynolds was unable to make that lump sum payment and did not enter into the agreement. Given all of this, I'm asking for the stay to be lifted today on we are receiving some payments, but it's not anywhere near full payments. So I'm going to ask for the stay to be lifted on 15 days of the 35 that are imposed and stayed, and ask for the purge to continue for 1 year beginning July 1st.
Mr. Reynolds, do you understand what she is asking of the court?
Yep. Yes, I do.
So do you have a job?
Yes, I do. I've had one for 3 years.
And why aren't you able to, I'm going to tell you, I do recall in the other matter, you told the court you were going to make that lump sum.
What happened?
What happened there?
We haven't been that busy up there. I don't know. Like, I can't make people tip me. Like, some days I do good, some days I don't. And it's been real, like, down for me. So.
You have the ability to get a second job?
See, that's what I was thinking about. I was thinking of doing that because I work four tens, like 4 days a week, tens, and then I could work somewhere else for 3 and they could just deduct, and that would be like a paycheck job. And they could just deduct the full amount from there. Because like this tip thing, I don't know.
All right. So with regards to lifting the stay for 15 days of jail, what would you like me to know?
I guess I deserve that. I guess if you say I deserve it, I deserve it. Like, it's not like I don't take care of my kids or give my kids money. Like, you guys want it through here. Like, so.
Well, it's not that they want it through here. This is how it was originally filed in 2005, and a child support payment and amount was set.
Yeah.
And it needs to go through the court unless the mother of the child says opposite. So, Mr. Reynolds, do you believe you would have the ability to get that $2,000 payment?
When?
That was my question. Do you believe you can? And then when?
What day is today? It's Wednesday. See, I work tonight, tomorrow night, all the way till Saturday. And then we get a $500 payment on Friday from the tribe that I could put up.
So do you think you can get that $2,000 payment soon?
Yeah, if I could get it probably this week, if not, like close to it. Like, I just gotta work harder on like customer service skills, I guess. I don't know.
Can you get the payment by July 25th?
Yeah.
And you're confident you can do that?
I'm confident in everything I do.
Okay, well, the court is going to, I'm going to lift this, well, I'm not going to exactly lift the stay right now. The stay will be lifted on July 25th if you have not paid that $2,000 down payment. Okay, so you have until July 25th, because if you don't pay child support by then, all they need to do is send me the order that says he didn't, and now lift that stay on that 15 days.
Fair
You
enough.
understand?
Fair enough.
Okay, so you have until July 25th to get that money to child support.
Okay.
And will the purge be extended for a year?
Yes, and the purge will be extended. It is extended for a year at the same purge conditions. But I'm giving you this last chance, Mr. Reynolds,
No, thank you.
because that's gonna help you in all your matters. Okay?
Yeah.
All right, anything else, Ms. Thomas Schmidt?
I don't believe so.
All right, anything else, Mr. Reynolds?
No.
You can come, we didn't send a notice, so you are good to go. Just remember, July 25th, okay? Thank you.
Next one up I have is Gina Walker. Jean?
We are on the record in 25 TR 800, State of Kansas versus Gina Lynn Walker. Jared Regier for the state, Gina Walker in person. Miss Walker, you are charged with driving in Butler County, Kansas on April 11th of 2025 without proof of liability insurance. This is a B misdemeanor. It does carry a fine of at least $300 up to $1,000 and up to 6 months possible sentence in the county jail, although diversion is an option. I'm sorry, probation is an option. You do have the right to an attorney. You can hire any attorney of your choice. You cannot afford to hire an attorney, you can apply for court appointed and see if you qualify. Or you can waive your. Someone needs to turn off the YouTube. If you cannot afford an attorney, you can apply for a court appointed and see if you qualify. Or you can waive your right to an attorney and represent yourself. There is a diversion program. However, I'm looking at your record and see they have some age to them, but you have a couple of things on there for traffic already. On the issue of attorney, how do you wish to proceed?
I'll represent myself.
All right, but you do, for the record, understand you can hire or apply for court appointed.
Yeah.
And you want to waive your right and represent yourself?
Yes.
Is anyone making you give up your right to attorney today by threats or promises?
No.
All right, if you'd sign the waiver in front of you then.
Okay, that's good. She signed the written waiver, Judge.
That will be noted in the journal entry and the docket notes. How then, Miss Walker, do you plead to the insurance? And before you answer, let me advise you that you can plead not guilty, denying the charge, and we'll set this for trial at a later date. Or you can plead guilty, admitting the charge, and we'll proceed with sentencing. Or you can enter a no contest plea where you don't admit the charge, but you don't deny it. You stand what we call mute, saying nothing basically, and you'll still most likely be found guilty and proceed to sentencing. I mentioned diversion. You can apply for diversion, but it does have a fee for applying, and if you're approved, there is a fee, but they do look at your record, and I do see you have some traffics on there and some other things. Do you want to have an attorney represent? Well, you said no on the attorney. Do you want to look into diversion or set this for trial or enter a plea today?
Well, if there's no chance of diversion, I'll just go ahead and go with the guilty.
Well,
if I've already got the diversion from the past, it's gonna keep me from being accepted. So.
It very well may. Understand, I'm not the one that makes that determination, but I've told you some of the things I know they do look at.
Okay. Well, yeah, I mean, I didn't have insurance, so there's no reason to prolong it anymore.
All right, so you're pleading guilty. Admitting?
Yes, ma'am.
You understand with the guilty plea, You will not have a trial on this. You will most likely be convicted and unable to appeal your conviction.
Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises?
No.
So you're admitting that you drove in Butler County on April 11th, 2025. And would that have been, as the officer says in his citation, let me see. What is that he's saying? Oh, that's her driver's license. He's saying you drove on Highway 54 and that he stopped you around mile marker 226.8 east.
Right at Andover Road.
Andover Road inside of Butler County. Okay.
Yes. I was in the process of moving my car I needed to move. So I was moving my car from one home to the new home and it was barely running. So when he pulled me over, I didn't have insurance. I hadn't been driving the car. It had been sitting in a driveway and it's still not running. So, but I have to carry my SR22 and keep insurance on a vehicle I'm not driving. So it is what it is.
All right. Well, I will find that you are knowingly and voluntarily entering this plea. You've provided a factual basis and jurisdiction, so I will find you guilty of driving without insurance. Mr. Regier, does the state have recommendations for sentencing?
Your Honor, on the sole count currently before the court, the state is prepared to recommend the statutory minimum fine, court costs, 120 days jail sentence, suspended, subject to a 6-month non-reporting probationary period. This is a defendant who seemingly appears pursuant to the notice to appear date on the ticket, and the state has not received any information to suggest that the statutory requirements of KSA 21-2501 subsection B have been satisfied at this juncture.
Thank you. Miss Walker, anything else you want to say before I pronounce the sentence? You don't have to, but you're welcome to.
No.
Okay. Well, I am going to order the statutory minimum fine. Unfortunately, that is $300. I also impose court costs of $108. How much time do you need to pay that?
Can I pay 300 today? I just owe the 108 remainder. I can pay it in a week or so.
Okay, how about if I say pay within 30 days and you pay what you can today and the rest by 30 days? Will that work?
Yes, ma'am.
All right. And then I am going to order not the 6 months allowed for this, but 120 days. But that is suspended. You will not serve that so long as you're successful on a 6-month non-reporting probation. Non-reporting means you're not going to have a probation officer. You're going to have to do this on your own. But you only have 3 conditions, and the first is do not violate any laws during this 6-month probation. The second is to pay the total due within 30 days. And the third is to make arrangements with the officers, if you haven't already, to get your picture and prints taken. I am required to order that on any A or B misdemeanor.
Yes, ma'am.
If you miss the time they give you to do that, then that's a violation of your probation.
I'm set up to go at 1:30 today.
Very good.
For pictures.
All right, so you're well on your way to getting this taken care of. If you do everything you're supposed to, in 6 months, the case will close and you won't have the threat of jail time or probation over you. But for 6 months, you do.
Okay. Thank
All
you.
right. Mr. Regier, anything further? The record will reflect she's waived counsel orally and in writing.
No, nothing further from the state, Your Honor.
All right. Anything further, Ms. Walker?
No, thank you. No.
You're welcome. You may go.
Your Honor,
Yes.
I apologize. If we can address it real quick, I just got a message from the Eric ID. It's our Kenya Wanda interpreter who's here now. Not sure if you would like to release them or not.
I was like, what?
Yes, he's released at this time. We'll need him. If the defendant doesn't pay his infractions, we'll need him back here, but we'll let him know. So is he on the screen with us?
He is, Your Honor. It says Eric ID.
Okay. The gentleman, Mr. Eric, I didn't know that you were going to be here. The defendant was looking at 2 infractions. I sent him over to the official interpreter docket date because he only had a friend here to interpret. But he's indicated he's going to pay his 2 infractions, so we may not need to have the hearing on the interpreter docket of what is that date we put that on? October 8th. All right. Thank you for being here. Appreciate it.
You're welcome.
You're excused at this time.
Okay, next one I have up, Judge, is Patrick Sample, Sampoll. He was kind of a late add-on, so.
Oh, okay. Well, let's look at the computer. Yes, he was a late add-on. We are on the record in 25 TR 802, State of Kansas versus Patrick Allen Sample. Jared Regier for the state, the defendant, Mr. Sample, in person. Mr. Sample, you have 1 charge of operating a motor vehicle in Butler County, Kansas on April 11th of 2025 with a vehicle being, the vehicle you were driving had a one-way glass or sunscreen device that was allowing in less than 35% of light. This is an unclassified misdemeanor. If convicted, your penalty could include a 30-day sentence and up to $500 in fines. The statute does allow, however, if you take proof that you've removed the sunscreen to the county attorney or to the court, it will be dismissed. So, do you wish to hire an attorney? Because I cannot appoint one since it's only a 30-day sentence possible. Or
No, ma'am.
You want to waive your right and represent yourself?
Yes.
All right, there's a form there for you to do that. Is anyone making you waive your right to an attorney?
No, ma'am.
Okay, you want to look that over?
There's a print here.
Yes, that's right there.
Sit down and relax, okay? Okay,
Someone, I think it's Tino, could you mute so you don't keep broadcasting in our hearings for other people? There should be a little red microphone with a line through it that you can click on, and then we won't hear your conversations. All right, did you sign that waiver then, it looks like?
Yes, ma'am.
Now, okay, thank you. Now, do you want to plead not guilty and set this for trial? Or do you want to admit it and proceed to sentencing? Do you want to plead no contest, neither admitting nor denying, but still being found guilty? Or do you want to remove the window tint and have the charge dismissed?
Remove it and have it dismissed.
All right, so is it still on the vehicle?
No, ma'am.
Okay, do you have the vehicle here today?
I do not.
Okay. Can you take it, do you have it where you can take it to an officer and have them confirm that it's taken off?
Yes, I can.
And then have them send that communication to the county attorney?
Yes.
All right, Mr. Regier, anything else you'd like for him to do to provide proof of removal?
Your Honor, the statute does appear to state pursuant to subsection D, quote, any driver who is issued a citation for failure to provide a signed statement pursuant to subsection C4 shall have 60 days to either produce in court a signed statement or review the material described in subsection C. If such driver produces the signed statement or submits proof to the satisfaction of the court that the material described in subsection C has been removed, then the court shall dismiss the citation. It would appear that the statute is quite clear as to what is required, as well as the 60-day time frame, which would now appear to be past that time frame.
Well, it says 60 days, and it says or appear in court. And am I understanding that your office would not be willing to consider dismissal upon removal at this point because it's past 60 days of the ticket?
Your Honor, at this point, I am not in a position to conjecture one way or another, only refer to what the statute requires, Your Honor.
I'm going to enter a plea of not guilty and set your case for bench trial August 27 at 1:30. Go ahead and have your statement sent to the county attorney's office. And I guess we'll see what their response is. If they will not dismiss it upon proof that it's been removed after 60 days, then come to court ready for trial and bring your proof then that it's been removed, and we'll see what the outcome of the trial will be.
Is there a way that we can settle that before so I don't have to come back, or is that required?
That's what I'm hoping you'll do. That's what I'm hoping you and the county attorney will do.
Okay.
They may make you go through their diversion program because it's been 60 days. But that's
okay. I wasn't aware that I only had 60 days to it. I just saw the notice to appear on my ticket. So otherwise I'd have had it handled.
Understood. And a lot of times the county attorney does give you some extra leeway, but that's their call to make.
Okay.
At this point. So, all right, you may go at this time, sir.
Thank you.
You're welcome.
Next up is Brandon Skilling with an S.
Okay. We are on the record in 2025 TR 1327. State of Kansas versus Brandon Lee Skilling, Jared Regier for the state, the defendant Brandon Skilling, in person and pro se. Mr. Skilling, you are here on one count of driving while your license was canceled, suspended, or revoked. This is a B misdemeanor. If you were to be found guilty, your sentence would include a fine of at least $100, but no more than $1,000. And you could have a jail sentence up to 6 months, but probation is an option. Sometimes diversion is an option, but you have to have a pretty clean record, and I'm seeing quite a few things. I don't see diversion being in your future with all the priors you have, but it is something that if you want to apply for, you can, but it does cost to apply as well as cost to accept. Otherwise, you do have the right to hire an attorney, or if you cannot afford an attorney, to apply and see if you qualify for court appointed, or you can waive your right to an attorney and represent yourself. Do you wish to have an attorney, sir?
Yes, please.
And are you going to hire an attorney or apply for court appointed?
Apply for court appointed.
All right. Are you employed, Mr. Skilling?
Yes, ma'am.
Where do you work?
Spirit Aero Systems.
All right. Married or single?
Married.
Spouse work?
No.
Children? Minor
Yes.
children that you support?
Yes.
How many?
3.
All right, I'm going to have you fill out an application. The officer can give you one. And if I can get that. Destiny, is it possible to get that back to me before by email today before he leaves the courthouse?
I possibly could, Your Honor. It depends on how quick it gets over to me and I can get it faxed and scanned in.
Okay. All right, well, Mr. Skilling, take that application, find a quiet spot, fill it out, don't leave it blank. Make sure you sign and date it, and then get it back to the officer. And
Okay.
we'll recess your case for now.
Okay, next one up I have is Libby Wood.
We are on the record in 2024 TR 2414, State of Kansas versus Libby Leanne Wood. Jared Regier for the state. The defendant, Miss Wood, appears in person and pro se. Miss Wood, at the first appearance on speeding 77 and 65 and driving without a license, a B misdemeanor, you told me you were going to look into diversion, and then you failed to appear in March. So what do you have going on these charges? Did you apply? Did you get accepted?
Okay, so on the diversion, I did not try to, I didn't have the information that I needed, and I thought that my court date was a different day than what it was, so I was late on the court. That's why I had missed court. It was not my intention to miss court. And then I didn't know what to do, I guess, from there. So I have not, but I did get my license after that, so.
Do you wish to hire an attorney, apply for court appointed, or waive attorney and represent yourself?
I guess. I don't know. I guess just myself.
Well, an attorney can help you.
Okay, yes, will you do that? Sorry. Yes, a court appointed attorney.
I didn't finish. An attorney can help you decide what to do, but if you know how to proceed on your own and want to, you can do that as well. So I don't want to talk you into or out of an attorney, but what's your position?
Yeah, just an attorney.
Now, I have to make sure you qualify if you're going to apply for court appointed. Do you work?
Not right now.
Why are you unemployed?
Well, I'm an in-house caregiver, but I'm waiting on the paperwork to go through. So I still, I'm sorry, what?
How long have you been unemployed?
For about, I guess on paper, like a year, maybe.
So who's
But I still
supporting
have been working for him. Like they pay me, like I work for this guy and I work for this lady and they pay me. We're trying to get it to go through the veterans paperwork is what's happening. So it's taking some time, but
So you are working.
yes.
How much do you get paid every month?
Around 500.
Okay. I know you married or single?
Single.
Children?
No.
Okay. You live with anyone?
No. Just a gentleman that I take care of. So it's an in-house. Yeah.
So he's also providing what, room and board as well as the 500?
Yes, ma'am.
All right, it sounds like you'll probably qualify for an attorney, and I'll appoint Darren Patterson, but you must still fill out the application and fill it out completely. Don't leave it half blank. Don't fail to sign it. Make sure you sign it and date it.
Okay.
And you can leave it with the officer, but I am going to appoint Darren Patterson.
Okay.
And the officer can give you his name and number. You go directly across the street to Mr. Patterson's office and give him all your contact information and your case number and your court date. which will be September 22nd. You must be back here by Zoom or in person, whichever you prefer, September 22nd, 8 a.m.
Okay.
All right. You are on a $5,000 professional surety bond after missing court, so I will continue that. All existing conditions and the added condition that you go across the street to Mr. Patterson's office today and give them information and then reappear with Mr. Patterson on September 22nd, 8 a.m.
Okay.
Any
Thank you so much.
questions? You're welcome.
No.
Mr. Regier, anything further?
Not from the state, Your Honor.
All right, you may go at this time, Ms. Wood. You are excused and we're in recess on your case.
Thank you.
You're welcome.
Ashley Miller.
Was that Ashley Miller?
Yes, please. Yes. Yeah.
Okay. We are on the record in 2025 TR 728, State of Kansas versus Ashley Raynell Miller. Jared Regier for the state. The defendant, Ashley Miller, appears in person and pro se. Ms. Miller, you are charged with driving in violation of your restrictions on your license. Apparently driving without eyeglasses. This carries a fine of up to $200. A 30-day driver's license suspension is mandatory. You do have the right to plead not guilty and set this for trial. You can plead guilty and proceed with sentencing today. You can plead no contest, neither admitting nor denying the charge, but you would still most likely be found guilty and proceed with sentencing today. Depending on your history, if any, you might, you're not going to be eligible, I don't think, for diversion. I was going to say you might be eligible for diversion, but it looks like you may have had a diversion for
a while ago.
Well, yeah, 23 for expired tag and 19 for speeding. You were found guilty. So I don't think diversion is going to be an option for you. But again, I don't decide that. While you're pondering those things, though, Miss Miller, I want to comment that on April 15th of 2025, you called in to the clerk's office. You'd called in previously. And on that date, you spoke to one of the most friendly, considerate clerks. We have a lot of them, but the one you spoke to is exceptionally good at helping people. And you proceeded to curse at her multiple times, repeatedly saying that the quote, the officer had written this stupid, paraphrasing, effing, back to quote, ticket, just so he could make money from you and make a stupid quota, end quote. You repeatedly asked what your costs were. The clerk informed you that there would be court costs most likely added to your case, depending on what you were cited for, but without seeing the ticket, she could not inform you of the other fines and fees. You told her that this was stupid. It was stupid that it had gotten here in the first place. You told her you were cited for something stupid because you've never worn your glasses and you didn't know why it was ever marked on your license anyway. You asked if you had to appear in court for this stupid ticket. The clerk told you that she could check by looking at the bottom, or that you could check by looking at the bottom of your ticket, that if a specific box was marked, then you would have to appear for court on the date and time indicated. You again said it was completely stupid that you had to appear for court and that you couldn't believe you had to pay court costs and everything, even though you thought this case was dismissed or should be dismissed. The clerk went on to try to tell you that if it was dismissed, you may not have to pay any fines or fees. And then you hung up on the clerk before she was able to get a response.
I'm not sure as to what this has to do with the clerk, considering we're in court right now. So I'm confused.
It has everything to do with the clerk because it has a lack of respect for the court. It is the clerk of the district court. So when you disrespect the clerk, you're disrespecting the court.
So if she's disrespectful towards me, that's invalid is basically also what you're saying though.
Well, I'm saying the particular clerk that you encountered is, to the best of my knowledge and belief, extremely courteous, patient, and polite.
And generally when I had called, I was trying to be patient, courteous, and polite and treat her with kindness and respect, but she was extremely short with me. Also, I'm autistic. This is about facts, and I don't understand why we also have to bring feelings into it. It's inappropriate for me to bring feelings into it, so that's wrong of me, and I own that. But also, I don't want them bringing their feelings into it either. This is about facts. I'm trying to get the factual information so I can do what's needed of me to be a law-abiding citizen. So
this has nothing to do with feelings. This has to do with respect, which is a sign or symbol that you appreciate the role of the court, that you respect the law, and so far you've not shown that. And that doesn't help you get very far. So I'm telling you that your tone even today is questionable. I don't accept the fact that autism just makes you rude.
I never said that. You said that.
Yes, I did, because that's what I conclude, that you're being rude.
I'm not trying to be rude at all.
All right. Well, you are being rude. Now, Miss Miller, whether you think this charge is stupid, whether you think you need eyeglasses, apparently someone tested you at some point in time and said you do. And that if you don't wear your eyeglasses when you're driving, that could be a risk to other motorists and pedestrians or even to you. But that is to be determined at a trial. Do you want a trial on this charge?
Considering I've recently gone and gotten a new driver's license and I passed the eye test, I guess I'm unsure. I didn't realize it would even get this far where we are going to have to go to trial over somebody marking it was wrong on it shouldn't have been marked because I passed every vision test. So I don't understand. I'm extremely confused so I guess we're going to have to go to trial.
All right, I will enter a not guilty plea. We will set this for bench trial. You must be back here for bench trial, August 27 at 1:30.
Your Honor,
Yes,
I apologize. It'll actually be September 17th. August 27th is full.
thank you. We will set this for bench trial, September 17th at 1:30. And if you wish, you can ask the officer in cross-examination about his quota or whatever you wish. And this is not one that she has to get her picture and prints taken. I don't have to post a bond. Anything else, Mr. Regier?
No, Your Honor.
All right, anything else, Miss Miller? You do have the right to hire an attorney, but because the maximum sentence is 30 days and not 6 months or more, I'm not in a position to appoint an attorney. But you certainly can hire an attorney or you can continue to represent yourself. Anything else? All right, then you're excused at this time, Miss Miller. Thank you.